Yes, Mr. Tolimir.
Thank you, Mr. President. We will skip a portion, and I'll say that we are starting from item 127 for interpreter's sake. In a word, it was a plan of the Muslim authorities to evacuate the entire population, and you can glean that from the conversation between Ali Izetbegovic and the population of Žepa. Item 129. This exhibit clearly demonstrates, namely D54, that the evacuation had been planned secretly by the BH Federation leadership, and that it had been kept secret in order to accuse the VRS of attacking the civilian population and driving them out. Paragraph 130, we're reading sentence 5. General Benjamin Kurovac and Hamdia Torlak have come as authorized representatives for these negotiations in the manner envisaged under the relevant rules of the Geneva Conventions. At this meeting, Hamdia Torlak stated that the best solution would be to evacuate the entire population of Žepe. When asked by General Mladic whether there was anyone who wanted to stay, he answered in the affirmative and said that there were 10 families who wanted to stay. And this is proved by the video clip introduced into evidence as D108. I'll now move to paragraph 132. On the other hand, the Ministry of the Foreign Affairs of the BH Federation had asked the Security Council back on the 17th of July to carry out the evacuation, as corroborated by D107. This is the President's letter to the Security Council dated the 20th of July 1995, which requests the Security Council to, or rather this is the release by the Security Council requesting the Bosnian Serbs to cooperate in this matter. Let's move on to 134, Exhibit D58. On the 24th of July 1995, the agreement on the disarmament of the able-bodied population in the enclave Žepa was signed. The prosecution deny any importance that this agreement may have. That's at paragraphs 426 to 431. However, from the perspective of international law, this agreement is completely valid and in keeping with the Geneva Conventions. Its primary role is to ensure that the Žepa brigade be disarmed, and as for the civilian population, item 7 of it states, and I quote, that the civilian population of Žepa shall, in keeping with the Geneva Conventions of the 19th of August 1949 and the additional protocol of 1977, be granted the freedom of choice as to whether to stay in the area for the duration of the war conflicts. In other words, nobody was being expelled. It is only a matter of circumstance that the agreement was stipulated in the context of combat activities, but that does not detract from its validity. Let us move on to paragraph 135.
The role of Tolimir
during the evacuation of Žepa was to work on the implementation of the 24 July agreement and to make sure that the evacuation is without any incidents. Tolimir was in the center of Žepa, escorting the convoy together with the commander of the Žepa brigade, Avdo Palic. And now we move on to paragraph 138. This is for the benefit of the interpreters. The participation of Tolimir in the implementation of the evacuation of the population of Žepa in keeping with the agreement which was signed on the 24th of July 1995, the evacuation of the civilian population, including some military able-bodied men, cannot be considered participation in any criminal enterprise. Contrary to what the prosecution alleges in paragraph 60 under D1 of the indictment, Tolimir made sure that the evacuation of Žepa was carried out without any problems in keeping with the agreement that was signed on the 24th of July 1994. When it comes to the evacuation of the population of Srebrenica, in that evacuation, Tolimir did not play any role. He did not participate in it. The only thing that he suggested was to make a list of all militarily able-bodied men, including those that were to be evacuated from the Potocari base. In keeping with Ali Izetbegovich's plan, the civilian population was indeed evacuated from Žepa in a safe manner, and the BIH army did not lay arms, but rather they continued fighting. General Smith, on page 11597 of the transcript, testified that in Belgrade, Carl Bildt negotiated about the transfer of the Žepa brigade across the river Drina into Serbia. This is also mentioned in Viktor Bezbechenko's report entitled The Fall of Žepa. This is exhibit D55. Ramo Čardoković led the transfer to Serbia. He was the chief of staff of the 285th Brigade. The prosecutor treats that transfer of the Žepa brigade as a crime of deportation, which is charged in the indictment. Exhibit D111 is the list of those who had crossed Drina and who had been treated as prisoners of war in the Republic of Serbia. You can see in this list that all those were militarily able-bodied men who had been army members. For a crime of deportation, it is necessary for those persons who crossed the border resided legally in the territory of Žepa. However, their stay in Žepa was illegal. It was contrary to the agreement of the demilitarization of the enclave, according to Article 5 of the agreement on the demilitarization of Žepa. They should not have been allowed to enter or to stay in the demilitarized zone. Additionally, they crossed over to Serbia of their own choice in agreement with UNPROFOR members and the government in Serbia. And they were guided by the representative of the international community, Carl Bildt. There is no single piece of evidence based on which one might conclude that the VRS wanted to expel them across the border. For those reasons, the conditions for deportation as a crime against humanity have not been fulfilled. In the last paragraph of D488, it is stated, and I quote, "We believe that the destruction of the convoys of Muslims from Stoblice and Velička Planina, the Muslims would be forced to surrender very quickly," end of quote.
Just was reminded that this is a confidential document. When you quote from this document, you should be aware of that.
I didn't understand what document is confidential. The 111, very well, I apologize. Well, you can protect it. I did not understand that it was a protected document.
488, you asked, or you referred to when you started to quote from it.
It should be P488. I misspoke.
To clarify the situation, P488. Please continue.
In the last paragraph of that document, it is stated, "We believe that the destruction of the convoys of the Muslim population from the directions of Stoblic, Radele, and Verloška Planina, the Muslims would be forced to surrender quickly." First of all, when it comes to convoys, we're not talking about the civilian population, but about the destruction of those features that might be used for as hiding places for the population. For example, caves, different areas on the ground. Mirko Trivšić testified about that on transcript pages 8625 and 8626. The word convoy does not refer to the evacuees, but the features on the ground that may be used for hiding. So Tolimir does not suggest that the population should be destroyed as it is ascribed to him, but rather places where the evacuees could hide.
Paragraf 152.
Paragraph 152 for the benefit of the interpreters. When it comes to the alleged participation of Tolimir in the alleged joint criminal enterprise, and we are talking about the killing of militarily able-bodied men in Srebrenica, the prosecution bases its allegation on Tolimir's position as the assistant commander for security and intelligence. However, when it comes to Zdravko Tolimir's participation in the alleged operation of the killings of prisoners of war, there is no evidence to that effect. There can be no credible evidence. In the course of this trial, not even the witnesses who struck a bargain with the prosecution about the admission of guilt did not charge Tolimir. Paragraph 153. When it comes to the consideration of the charges that Tolimir has been charged with, when it comes to the killing of militarily able-bodied men in Srebrenica, it has to be mentioned that Tolimir was engaged in Operation Žepa during that period of time, and that there is no single piece of evidence that Tolimir, in the relevant time period, at all knew about any operation to kill militarily able-bodied Muslims. Page 54 of the document that I'm reading from. Where it says, in a series of paragraphs, the prosecution alleges that is the last word in the last sentence, that Tolimir commanded, controlled or provided instructions to certain people who were in Srebrenica. From the 12th of July onwards, this is not founded at all. There is no single piece of evidence to that effect. During the trial, the prosecution several times referred to P112. This is the instruction on commanding the security organs of the VRS. That instruction was issued in peacetime. Due to the omissions that were observed in the work of the intelligence and security organs. In this document, it is stated, and I quote, "The security and intelligence organs are under the immediate command of the commander of the institutions to which they belong. In professional terms, they are subordinated to their superior commands." When it comes to professional command and control, I'm not talking about issuing orders, but rather the authorities that are vested in any officer, and that is to direct the work of the organ and to make sure that they are properly trained. When it comes to the brigade corps, the security organs are independent and they perform the tasks of counterintelligence and other tasks envisaged by the relevant regulations. The assistant.
Let me interrupt you for a moment. You refer to P112. You see on the screen that these are photographs. It should be in a different document number. Can you repeat the number, please?
P1.
P1112. The assistant commander of the main staff of the VRS does not command. He only professionally guides his troops and works on the tasks entrusted with him by the commander. Otherwise, the principle of the singleness of command would be impaired. When it comes to the control, that can only be professional control, nothing else. And it doesn't imply the control of the organs of the security in the course of combat activities or any other task. This is the task of a commander. In order to control the work of the organ of security or any other organ, the person who controls that work has to be present, or he has to be provided with appropriate reports, also known as the reports of the security organs. They are not sent to Tolimir, but to the security administration. Where Tolimir was during the evacuation that he participated in, nobody was killed. As for the rapport between the commander and the security organs, this can be best illustrated by the testimony of the prosecution witness Kiserovic, who said that on the 16th he received an order from General Mladic. As a security organ, he received an order from his commander to go on a mission to abort his regular activities. he could not obey that. He had to do that. He had to come back and report to the commander. This illustrates the relationship with the commander and the security organs, irrespective of who the commander is, irrespective of who is subordinated to whom. Everybody is subordinated to the commander. Professional services have only a professional role that facilitates the implementation of any task. When it comes to the events that ensued after the fall of Srebrenica, there were no such reports at all. There's no evidence that Tolimir was aware of any killing operation at the relevant period, and that the reports were sent to him at Bokšannica. That was the front line facing the Muslims. That was an unpreferred checkpoint where negotiations were underway. No reports could be sent there. No reports indeed arrived there. The prosecution alleges in paragraph 89 of its final brief that Tolimir was the only person in the main staff who was authorized and capable of controlling the security organs and controlling them in the implementation of the order to expel the civilian population and the militarily able-bodied men. First of all, Tolimir did not have the right of command over the security organs. Only the commanders had that right. The commanders of the units to which those organs belong, including Keserovic. Second of all, control means presence at the location where killings are being committed. Tolimir was neither in Srebrenica nor at any other locations where the killings were committed. During the prosecution case, we did not hear any piece of evidence. We did not hear any witness testifying to the fact that Tolimir was informed about the operation to kill militarily able-bodied men. We didn't hear that he issued any proposals, instructions, or any other such thing involving the killing of the prisoners of war. The prosecution alleges that Tolimir I quote, applied his professional knowledge and skills within the purview of military strategy in order to coordinate the work of intelligence and security organs and agents. That is in paragraph 2 of the final brief. This also involved the military police that were used in order to implement that goal, unquote. And this is a reference to objectives contained in the allegation about the joint criminal enterprise. The prosecution does not have any proof for this allegation.
Nema pravo da komanduje.
Under the law, Tolimir has no right to command the security intelligence organs or police organs. They are all subordinated to their respective commanders. We are going back to Keserovic's example, who appeared here as a prosecution witness,
Morao da izvrši zadatak komandant.
who had to carry out the task given by the commander and then had to come back and report to him. And in the process, he had to suspend his activities in training police force.
Čitam tačku 160.
I am reading paragraph 167. Another document cited by the prosecution supporting the alleged contribution of Tolimir to the killing operation is the Defense Exhibit D49, which is a document sent by Tolimir from Žepa on the 13th of July 1995. It clearly confirms that Tolimir had no knowledge whatsoever about the alleged plan for killing prisoners of war. Please, document D49. It clearly shows that Tolimir did not have any knowledge about the alleged plan to kill prisoners of war. In paragraphs 572 to 585, the prosecution is making a speculation and offering completely unreasonable conclusions. First of all, in this document, Tolimir says, and I quote, "If you are not able to provide appropriate accommodation for all prisoners of war from Srebrenica," this part of the sentence indicates that Tolimir is not addressing the issue of the accommodation of prisoners of war Srebrenica, but that this is being done by somebody else. This sentence only indicates that Tolimir has no responsibility and no duties with respect to prisoners of war of Srebrenica. Secondly, Tolimir insists on appropriate accommodation, and that can only be construed as accommodation that would be in compliance with the rules of the Geneva Conventions, which was explained in the final brief. Tolimir also says that in the facilities of the 1st Light Brigade, there are proper accommodation facilities that can house 800 prisoners of war. Witness Charkic on transcript page 12740 testified that the facilities and Siemens were used for a certain period of time as billeting facilities for one of the Rogatica brigade units. Therefore, the prosecution's allegation that the accommodation was not suited to its purpose was unfounded.
Drugo, treće u stvari, ovaj dokument je poslat u večernjim satima 13.
Thirdly, this document was sent in the evening of the 12th July 1995 at around 10 o'clock. This cannot be interpreted as the fact that Tolimir was informed about the killing operation or about any unlawful treatment of prisoners of war. Interpreter's correction, 13th of July.
Što se tiče tvrdnji tužilaštva da je
As for the prosecution's assertions that
komandovanje na organe bezbednosti naletili su
Tolimir warned about the
komandnim organima koji imaju
drone. He, in fact, informed combat organs that had capacity to destroy such aircraft. In that period, the VRS was under the threat from air attacks. This is document 128, which was sent only to the Drina Corps Command and not to intelligence and security organs. As I said, The VRS was in the said period exposed to a threat from NATO, and therefore the information about drones was something that was regularly provided, which can be seen from Exhibit P1216 issued by Milenko Živanović on the 5th of July 1995, who was the commander of the Drina Corps, which means that this was one day before the commencement of Krivaja operation. The document reads: due to the possibility of NATO airstrikes, all subordinate units of the Drina Corps, so I repeat, due to the possibility of NATO airstrikes and the operations conducted by rapid reaction forces around the enclave, particularly around the enclave of Srebrenica, and with a view to providing protection to our forces from airstrikes, with the focus in the general area of Srebrenica, all subordinate units of the Drina Corps and all anti-aircraft units within subordinate units, as well as the available small arms and common weapons, shall be placed at full combat preparedness in order to act in a timely manner against enemy aircraft, and thereby be ready to operate with all available weapons to attack helicopters used by rapid reaction forces in order to prevent flights over the front lines, and thereby risking the safety of our forces in depth. Open fire at aircraft and helicopters without seeking particular approval.
Su nelogične, jer je letvac
the allegation that
čitam sada
can Mr. Tolimir please repeat?
prevodioca.
For the benefit of the interpreters, I'm reading paragraph 177. Following a completely unreasonable conclusion contained in paragraph 769 of the prosecution's final brief, in which the prosecution makes reference to an intercept of the conversation between Tolimir and Popovic, has nothing to do with prisoners of war of Srebrenica, namely, I'm talking about P765, which states that Popovic was inquiring about a relative of his who had been taken prisoner. However, the prosecution extracted only one portion of that intercept and draws from it completely unreasonable conclusions. The relevant portion reads: Popovic, I am today in my base and I have some things to complete, therefore I remained here. Tolimir is doing his job, which means that Tolimir was in the base and not out on the ground. The most striking example of speculative arguments is something that the prosecution stated in terms of interpreting the words, he's doing his job, as a criminal order. This document clearly shows that Popovic was in his barracks, in his office, and that he spent the whole day there. This conversation cannot be used as proof that Tolimir gave any order to Popovic with regard to prisoners of war, Srebrenica, particularly not what is being cited by the prosecution in paragraph 775 in their final brief.
tužilaštvo stavlja Tolimiru
The prosecution charges Tolimir for supervising the 10th sabotage detachment on the 16th July and 23rd July while they were committing murders in Branjevo and Bišna. First of all, there is no evidence indicating that Tolimir was aware at all with the activities of members of the 10th sabotage detachment at any location. Viktor Bezruchenko says that on the 16th of July, Tolimir sent information from Žepa. Secondly, the sabotage detachment, as explained earlier, was an independent unit of the main staff, and it was directly subordinated to the commander. This was testified to by Petar Salapura and Petar Škrbić. There is not a single shred of evidence that Tolimir either commanded or made any decisions with regard to the engagement of this detention. Interpreter's correction, detachment.
ostali deo dokumenta, da ne bi sad...
I will take you up on your offer, and I will read the rest of the document, about 10 pages tomorrow. Tolimir mentions, or rather, the prosecutor speculates about Tolimir's participation in the joint criminal enterprise, namely killings. On page 20, lines 14 and 15, the prosecutor alleges that Tolimir knew that Beara was in the Drina Corps. In the relevant time period, Beara was subordinated to the Drina Corps, and this information was available to all sector members. But Beara did not report to Tolimir. He did not inform Tolimir. It is unfounded when the prosecution alleges that Tolimir supervised Beara and that Tolimir knew what Beara was doing. And this is what the prosecutor said in the final brief on 27, that Beara called Krstic, and why didn't he call Tolimir? The prosecution suggests speculatively that he didn't do that for his own reasons. However, Beara could not report to Tolimir because Tolimir had never sent him on a mission, and he was not accountable to Tolimir for the tasks that he was assigned to. He was subordinated to the Drina Corps, and he reported to the Drina Corps. The prosecution does not have a single piece of evidence about any communication between any of the participants in the events of the killing on the one hand and Tolimir on the other. And he doesn't have a single proof of evidence about Tolimir's activity in that. There is also speculation about Tolimir having criminally prosecuted two members of the Foinica Brigade for having helped Muslims. There is no single piece of evidence that Tolimir had filed a single criminal report and that he prosecuted any members of the Army of Republika Srpska for having helped Muslims. The security organs were not involved in criminal prosecution activities through Tolimir. Tolimir was never involved in any legal matters. It is the security organs did that directly in cooperation with the prosecutor's offices.
For the record, I think there is a problem in page 75, lines 23 and 24. I read, Tolimir was never involved in any legal matters. Is that what you were saying, Mr. Tolimir?
Organi Tolimir
Tolimir was not involved in filing criminal reports. He never prosecuted anybody. Security organs did not do that through Tolimir. Security organs cooperated with prosecutors' officers. Tolimir was not involved that. Security organs cooperated directly with the competent prosecutors' offices and courts. This is what I said in my conclusion, if that is what you had in mind when you intervened. Thank you. The prosecutor, in a number of their conclusions, referred to the testimony by Milenko Todorovic and his statement that Tolimir had told him that he would come to Batkovic to see 1,200 prisoners. Tolimir never said that. Todorovic could never confirm that. He didn't know when he spoke to and who spoke to, so his allegations are unfounded. Todorovic himself, in his testimony on the 20th of April 2011, when he was faced with the exhibit D226, on transcript page 13141, said, "Thank God I can finally see the document that shows, or rather about which we have spoken at such a length." He did not see that the document was issued in 1993. However, he saw that he was issued on the 16th of July. The document was signed by the Chief of Staff, General Manuel Milojevic, which points to the fact that Todorovic's recollection about who he had spoken to is not reliable enough. Additionally, Todorovic's commander, Novica Simic, who was also a witness in this case, or rather in the Popovic case, and his testimony was adopted through 92-quarter rule. He testified in the Popovic case, and the transcript from that trial was adopted as Exhibit P2756, and the relevant transcript pages are 28565 through 28570. Novica Simic, within the context of the topic of prisoners of war from Srebrenica, did not mention Zdravko Tolimir. However, he spoke about who he controlled, how he controlled them, who he contacted, and how he made sure that a certain number of prisoners of war were accommodated in the reception center in Batkovic. I would like to conclude for today the prosecutor's assumption that Mladic and Karadzic ordered Tolimir to manage and control the killing operation is not corroborated by any evidence. It is just an assumption which serves to deceive this trial chamber and the general public about Tolimir's participation in these killings. It is true that Mladic and Karadzic never provided Tolimir with any order with regard to the killing of prisoners of war. There is no single piece of evidence to prove that. There cannot be such evidence because it simply did not happen.
Mr. Tolimir, does that conclude your presentation of today?
Well, what remains is something that I would like to summarize in 15 or 20 sentences in the 10 minutes that you will grant me, as you promised. If you think that this would be a good ending to my closing argument.
Do that today because we are at the limit and we can't sit longer than 7 o'clock. But I think it's for your benefit to conclude your presentation tomorrow. We will have a sitting in tomorrow afternoon, and at the beginning you should sum up and conclude your presentation, and then you have some time to think about that again tomorrow in the morning, and to finalize your oral presentation. I think it's better than today to rush through the remaining part of your presentation. Would that be acceptable for you?
Thank you, Mr. President. I believe that I will manage to finalize my closing argument tomorrow within 15 minutes. I apologize once again to the interpreters and to you. Thank you.
Thank you very much. Then we will have the following program for tomorrow. First, the closing of the closing arguments, the remaining parts in 15 minutes. Then rebuttal by the prosecution, a possible rejoinder by Mr. Tolimir. It's up to you, and you may decide tomorrow what to respond to the prosecution. And that at the end we have to deal with some documents which are MFI'd, and we have to decide how to deal with them, as I indicated yesterday, and I hope the parties will be prepared to discuss this matter. We adjourn and resume tomorrow at 2:15 in this courtroom.
All rise, we will